everybody, welcome back to the Starved Rock Murders. I'm your host, Andy Hale. Excited to have back again Sally Cohen, my law partner, who is been doing a lot of the legal research, diving into some of the issues we've dealt with with Chester Weger's post-conviction petition. Sally, welcome back.
Thank you for having me again.
So today what I want to talk about, we've done two legal autopsies that basically went through the evidence we put on, errors that the judge made, factual errors, legal errors, the way Will County argued the case, and we probably could do 5 more episodes like that. Today I want to talk about some evidence that was not allowed at the third stage hearing, and I'll set the stage. So I retained an expert on false confessions. His name is Dr. Brian Cutler, who's done a lot of research on the field of false and coerced confessions. He reviewed the case. He did a whole thorough, I got this report in front of me. How many pages is it? With an appendix, 40-something pages. It's so thorough. It's so persuasive. And we submitted it as new evidence. And the court, when the court was going through all our evidence, ruled that this was not new evidence, which we'll talk about first. So this Dr. Cutler was not allowed to testify at our evidentiary hearing. And I think, and we'll talk about this as we go along today, I think he alone would have created reasonable doubt. I think if he'd have testified in 1961, I mean, he couldn't have, because obviously the science wasn't developed. But if a jury now, when they hear false confessions and the factors and the data and the research. So I want to start out first and say, what did you think of his report overall? Let's just first do a kind of a global, what was your overarching view when you read it?
Well, I was really fascinated by his report for a few reasons. Number one, it's so thorough, and it's like point by point by point. You can see exactly the factors that contribute to false confessions, and then boom, they're here in our case. So it was almost like a guide to how to get a confession out of somebody and how they used it against Chester. I also was independently interested in it because, I was a psychology minor, and it really is fascinating the way that humans respond to stress, to authority, to just their basic bodily needs. And so just learning about the more general area of false confessions and interrogations was really fascinating to me. So if anyone wants a little bit of late night reading, you can look at the report. I
am going to post it at the andyhalepodcast.com website. I will post Dr. Cutler's report there, and I urge anybody who's interested, read it. You can check it all out. So let's start with this issue. I know Dr. Cutler has testified in other third stage hearings in Illinois, in other third stage post-conviction hearings. And I was very surprised that our judge did not allow this evidence to proceed to the third stage. What do you recall the court's reasoning about that? And what's your take on it? Is this another one where the court got it wrong?
Yes. I think there were two primary reasons. Number one is that the court said that the voluntariness of Chester's confession was already litigated in the year 1960. So that was not an issue. So the court and the Supreme Court affirmed that his confession was voluntary. So he wasn't going to relitigate the issue of whether he falsely confessed. That was wrong because you can still challenge the reliability of a confession, even if it was found to be voluntary. So they can admit the confession, and you can have the opportunity to say, well, that was false. If you never were able to admit a confession that was arguably false, then you wouldn't have false confessions experts testifying anyway, ever. The other reason is that he said it's a new opinion on old facts. So the facts that underlie this report were known, and Chester did testify about them. But as you mentioned, Andy, the body of research that's been developed since 1960, police forces all around the world use very different approaches now because they're trying to prevent false confessions, and that was just not widely known at the time, and certainly not known by jurors.
Yeah, I that one just kind of shocks me. I felt like that was so egregiously wrong. The research, the body of research is all new. In fact, it's recent, really.
Yep.
That's like saying, the hair was around in 1960 and, we're just applying new technology to it. So it's not new. It's an old hair. I mean, that's just, it makes no sense. for the court to bar this. And, it's based so much on research and studies. There is actually a science behind it. So I look back on this, and at the time, I don't think it bothered me as much because I knew how strong our forensic evidence was. And I just felt like that was going to carry the day. And so some of these losses we suffered, I didn't get as upset about as I am now. But this one really bothers me. And this one, I think, would have been reversed on appeal as well. Because I think it's clearly new evidence, and it's so powerful and persuasive, right? It's so powerful and persuasive. So where do you want to start? You know this report really well. What's a good starting point?
So I thought it would be interesting for the listeners to hear just a little bit of the background that Dr. Cutler laid out in his report about the survey of research that's in the area now. And I thought that this was interesting because, the judge, having read this report, would also have learned this information. And I would think that would have been persuasive to him to edify him about the frequency of false confessions. So we can start there, I think, if you'd like.
Yeah, tell me a little bit about a background and what he laid out.
Yeah, so I think it's interesting. I learned this from Dr. Cutler, that there's actually 3 types of false confessions, and only one of which probably applies here. But the first type is a voluntary false confession. And that's when the person knows they're not guilty, but they voluntarily confess either because they're trying to protect another person or because they want notoriety. So you see that. I mean, how many people have confessed to John Benet Ramsey case? You see that, right?
Yeah.
But that's one that people think would never happen. Who would ever voluntarily falsely confess? That must be a crazy person. Well, kind of, yes. The other one is an internalized false confession, which is when the person begins to believe that they actually committed the offense.
Wow, that's so interesting.
Yeah, they can be convinced that they did it in their sleep, or that they did it without noticing, or, and they really begin to believe that they must have done it. That they did do it. So that's a really unfortunate one. The other one that probably applies here is a compliant false confession. And those are where the pressures of the interrogation lead the suspect to admit to having committed the crime, but they know they're innocent, and they're doing it for a bunch of different reasons. Dr. Cutler points this out, which is very interesting. If you're innocent and you know you're innocent, you go into an interrogation as an innocent person. So you're unlikely to call a lawyer. You're unlikely to invoke your right to silence. You're likely to try to be cooperative, and you're likely to protest your innocence. And those sorts of factors can increase the risk of false confession and the pressure on you because, first of all, you're unrepresented. Second of all, you're blabbering. And third of all, interrogators can get aggravated by protestations of innocence. So they go harder on you and harder on you. And innocent people are also likely to think that the truth will ultimately prevail, right? So they say, okay, I've been being interrogated for X amount of time. I'll just say I did it, and I'll be able to prove my alibi tomorrow or at trial. I'll just take it back. Well, that is not a good strategy, but it's one that an innocent person is more likely to take on just because they believe in their innocence and they believe in the system.
It's so interesting, that third example that you just talked about. So the well-known case here, and I've talked about this on this podcast, Kevin Fox, who wound up confessing to killing and sexually assaulting his young daughter, Riley Fox. She was like 4 years old or something. And I remember going to his civil trial and watching it. And this is maybe, it's more than 10 years ago, but not that much farther. And at the time I thought, oh my gosh, I would never, it's got to be true, because who would falsely confess to killing their daughter? Well, you know what? They wound up finding her shoes on a riverbank. They did, with forensics, they linked it to the real person. Kevin Fox falsely confessed. And what he said was exactly what you just said. He thought, I got to end this interrogation, and I know I'm innocent, I'll be able to easily undo this. Well, it wasn't so easy to undo. And I remember, me personally, probably wasn't until 10 years ago that I really understood false confessions are real, that it does happen. And think about 1960, okay? I mean, that jury, that confession was checkmate. I mean, really, realistically, I think all the jurors probably were struggling because the story made no sense. Mm-hmm. And that's why they rejected the death penalty. But the confession was a checkmate. It really was in 1960. And I think what's telling here is they tried to break Chester down, in late September when they took him to Chicago. And then they threatened him on the ride home with Dummett saying you're going to ride the Thunderbolt. All of October, surveilling him 24/7, threatening him. He's cooperating, like you said, all along the way with every step. And then finally, and it's so clearly the intent was to break him that they arrest him without probable cause. They just arrest him, putting him in handcuffs, and now they tell him you're gonna ride the Thunderbolt because you're gonna die. So it's so egregious. So this fits into the category of the third type of false confession. What does he say next about the factors?
Yeah, so there's two types of categories of factors that increase your risk of false confession. So there are situational risk factors and personal risk factors. So the personal risk factors are things like, lack of education, mental illness, sleep deprivation. They are characteristics of the individual who's being interrogated that make them more prone to falsely confess. And then situational risk factors are factors that apply or relate to the setting of the interrogation and also the tactics used. So when you have a confluence of both situational risk factors and personal risk factors, as we did here, you get a really high risk of false confession. So we can go into a little bit more detail on some of the personal risk factors, which were here.
Sure.
Power imbalance. Of course, in any interrogation, there's going to be a power imbalance, but between a highly uneducated dishwasher who's trying to cooperate and the authorities who seem to have all the information, that bleeds into a situational risk factor, which is exacerbating that power imbalance. So even techniques such as moving towards the suspect and speaking in a raised voice and taking an accusatory tone. So one of the ways to get a confession is to start from the premise that the interrogator knows the suspect is guilty and they don't back off from that premise. So they say, we know you did it, just confess. So they appeal to morality. They say, a good person would confess, like, don't you care about your family, that kind of thing. They also will do false evidence ploys, saying, we've got your fingerprints. They'll do appeals to leniency. They'll say, it'll be way better for you if you confess now. Those sorts of things. But the biggest situational risk factors beyond those tactics are the length of the interrogation and the setting, including being isolated, being alone. That's why your right to counsel is important. And then leveraging, if you're alone, they can, as they did here, leverage your ability to see your family. They say, your family's right out there. Why don't you just confess and get it over with, and we'll let you see them. So those are some of the factors and how it typically goes down. Interestingly, Dr. Cutler makes this point, which is that the techniques that get false confessions also occasionally get real confessions, right? You're going to confess eventually after all these tactics are used against you. So that's why it's really important, as was not the case here, for investigators to actually have evidence when they're interrogating somebody and really believe that their suspect is the guy, and then have ways to check that their confession is accurate. So we'll get to there in a minute, but there's lots of ways to ensure that a confession is reliable, none of which were used here. And there are ways to tell a false confession from a real confession. And here, if they tried to do that, they got it wrong.
And you talk about accusatory tactics. This actually starts in late September. When Harlan Warren, the state's attorney, undertakes his secret and kind of rogue investigation, and he asks deputies Dummett and Hess to assist him. And then Harlan Warren brings in his own polygraph examiner, John Reed. We're going to talk about that in a minute. John Reed, there is a John Reed, and his company was John Reed and Associates, and a guy named Stephen Kindig. And at that point, Chester's already passed 6 polygraphs administered by the Illinois State Police. So why they even thought it was necessary to give him number 7 is a red flag for one, because now they've set their sights on this kid. And then Stephen Kindig, when he claims that Chester failed number 7, okay, now he's passed 6 of 7. Let's say that was even true. So what? But yet now Dummett is threatening Chester on the way home from Chicago. They're taking him to Chicago the next day and threatening him, and he's there all day. And the crazy part is, after he's in Chicago all day, and they leave Chicago at midnight, get back to LaSalle at like 3 a.m, they don't take him home. They take him to the state's attorney's office. They keep interrogating this guy. I mean, it's if you heard it today, it would be so shocking today. It'd be such a scandal today. There would be a big deal if something like this happened today. And so talk a little bit about then the threats that are made.
Well, yeah, so I just wanted to pick back up on what you were saying. You know, the way that they were treating him and the relentlessness of their approach to him, honestly, like, to me, that could have produced an internalized false confession. You know, if you're Chester and you're like, what, like, did I do this? You know, like, why are they doing this to me out of nowhere, unless they really think I did it and they know I did it? I don't think that's what happens here. That's not what Chester said happened here, but you can see, like, those tactics were that accusatory and that relentless and that aggressive that you could see how it could produce a figment in your imagination that I must have done this. So I agree with you. Egregious, really egregious, including the surveillance and just they went way up the chain. You know, Harlan Warren is there. You got John Reed there. You know, they're just going to the top of the pile to get this guy. It's not their beat cops that are interrogating him.
Yeah, let me backtrack too. So this starts, you know, I kind of forget sometimes that there might be people listening for the first time who haven't listened to like the prior 40 episodes, you know. So Stephen Kindig, who was a polygraph examiner who worked for John Reed, and John Reed was I think a former Chicago police officer. So Stephen Kindig, we found out through our own research, knew Robert Murphy, the husband of Frances Murphy. I think that's a massive red flag footnote right there. And then when they take Chester to Chicago, so, you know, I've had in my practice now, you know, we've had cases where there's polygraph issues. We've had polygraph experts. You know, polygraph exam, my understanding, just, you know, can take a few hours. The person has to kind of, you know, they got to get all the machine kind of calibrated. There's a little bit of a kind of a pre-warm up to get the person comfortable. You ask them questions that are, you know, the key questions, and then there's kind of an assessment. All right, but why is Chester, why is he basically in Chicago with John Reed all day? Like, if they get there late morning, why is he there till midnight? You know, if it's 12 hours, what is going on for 12 hours? You know, like, talk a little bit about the length. What does Dr. Cutler say about the length?
So Dr. Cutler notes that between September 27th and 28th, Chester was interrogated for around 30 hours altogether.
Crazy.
Which is crazy. And these were not continual interrogations, but just that length of interrogation, whether you get breaks or not, is very excessive. And these facts are generally agreed upon by the parties, so they're not denying this. And we don't have records of that interrogation, which is, again, not something you would ever do today.
Right. We don't have any records of the transcript of what they were saying. Right.
So, you know, they call that an adverse inference in the law. When the evidence of what occurred is destroyed or not kept by one party, you can draw kind of the worst inference possible. And here, as you said, we've got him at John Reed's office for 12 hours. What are they doing there? We can, I think, infer that he's being interrogated using, which we'll talk about in a minute, John Reed's techniques. And what we do know is really bad, right? Like, we've got a lot of really bad facts about what happened there, including the writing the Thunderbolt comment, including threats about his family, going to the little green room. So that's just what we know. And I think that we can speculate that the actual interrogation was worse.
And I want to also note that we got through a relative of Harlan Warren. We've got these handwritten notes of Harlan Warren, and it's basically laying out, it just lays out on paper this plan to get him to confess. It literally says, get man to confess, break him down. I mean, that's what his notes say. get him to confess, break him down. I mean, that's exactly what they were doing. That's exactly what they were doing. And again, when this all starts in late September, there's never anything linking Chester to the crime. It's not like they said, well, we found Chester's hat, a quarter mile from the cave, so maybe he was out there. Or, oh, we found, there's literally nothing linking him to the crime. And so for them to go after him so hard, I think what we also have to put in context is, okay, these go hand in hand. This starts in late September, which is when, right after the Palmatier brothers have evaporated. Mm-hmm. So that's right after Glenn Palmatier gets interviewed by the Illinois State Police. I think it's August 30th. And his brother William, we don't have the transcript, was somewhere around then. And then like the next day, I think it's September 1st, are those profuse apology letters from Harlan Warren to the brothers, like, oh, we're so sorry that your name got dragged into this, like these crazy apology letters. So at that point, they have to have a plan B now. They made the real guys go away.
Yep.
They got to have a patsy, and that's when I think they thought, okay, it makes sense. Let's figure out somebody at the lodge, somebody who worked at the lodge. Oh, let's look at the dirt poor dishwasher, 21-year-old Chester Weger, and that's how it all gets rolling. Unbelievable.
Yeah, that's a really good point about the timing. When you consider in context the sort of the cover up and the desperation to solve this, but also to cover up who really did it, seems very evident when you put it in order like that.
The other thing too is, I think Chester Weger, I think what goes in his column is he withstood so much, right? So he withstood all the pressure in late September when they claimed he failed polygraph number 7 at the lodge. He was taken to Chicago. He withstood it all day, didn't confess. He's not taken home. He's taken to the state's attorney's office, withstands it, doesn't confess. All of October, they're surveilling him. They're following him, hounding him, harassing him. He doesn't confess. And that's when they did something that was so egregious that I still can't believe they even did it. They all got in a room and just said, you know what, screw it. Let's just arrest him. Like, they literally could not do anything else. They had tried everything. So they just arrest him. And what Chester testified at trial, because I thought this was I talked about this before. There's a part where Tony Ricculli is crossing Chester about the trip to Chicago. He's like, well, you didn't confess then. And Chester's like, well, I wasn't under arrest then. So my point is, you could tell from Chester's answer and demeanor, once he's handcuffed and it's real, it's now real. You're handcuffed and you're in jail. And you've been handed 3 warrants for murder. Now you got to be saying, holy shit, I'm in a deep, deep, deep amount of trouble. This 21-year-old dirt poor dishwasher who doesn't have the benefit of counsel or anybody really guiding him, this poor family, and so that's when the pressure got really, really ramped up.
Well, and I think I made this point the other week, but I think it bears repeating, especially in this context. Part of the reason that his confession was found to be voluntary was because there was an attenuation between the moment of the threats that were admitted, the ride the Thunderbolt comments, and when he actually confessed, right? He didn't confess on the day that they said ride the Thunderbolt. And so they said, well, then your confession can't be the product of those threats. Well, to me, that is just dead wrong, right? Because you're not going to get the electric chair unless you're found guilty, which means unless you're arrested, right? So when you can say that all you want, but if you don't confess and they have no evidence against you, you're not going to get arrested, or so one might think. Then once you're arrested, you've got to think to yourself, oh, they're coming for me. That threat animates in the back of your mind. It's still there, and they still meant it. And of course, they were relentlessly pursuing him all the while. So I just think that to the extent that that's the law, that the threat has to be proximate to the confession, that just makes absolutely no sense given the research about false confessions and how they accrue and way that people can be coerced into just trying to end the relentless situation.
And my understanding is he still received threats after he got arrested. So he testified that he's still getting threats, numerous threats from Dummett after he's arrested. You know, it started with that Thunderbolt comment on the way back from Chicago. And knowing what we know about Dummett, think about this. If Dummett was the kind of person who was going to threaten Chester on the ride home from Chicago, and it happened several times, that's what Craig Armstrong, the state's attorney who impeached him at trial, said. Dummett's the kind of person who not only makes the threats, lies at trial under oath and commits perjury and denies making the threats. Think about what Dummett must have been like once Chester got arrested, and now they really are trying to turn up the heat, right? I mean, Dummett must have been at his worst in those moments. I can't even imagine. And again, we don't have a transcript. We don't have an audio recording. We don't even have a police report talking about what was allegedly said in that room, you know, at all. So it's so, this part of the case, and us knowing how ridiculous the confession is in this story, it's so clearly got all the hallmarks of a false confession. I'm just so surprised, like when Will County State's Attorney's Office, who's representing the state, looks at this case, and their job is to seek justice, putting aside any evidence that we developed, and we had developed a ton, including the DNA, that you wouldn't just be like, oh my gosh, this makes no sense. In fact, when Celeste Stack and I met with James Glasgow, the state's attorney in Will County, he basically told us that the confession made no sense. He's like, it doesn't make any sense. It couldn't have happened this way, right? And so then when you hear these factors that we're going through, then it all makes sense, right?
Right. Well, and I wanted to move to a point here that I think makes it's a classic false confession in more than one way, not just the threats and the situational risk factors that were used to procure it, but also because what typically happens next in a false confession, once you get a suspect to admit wrongdoing, the next step is either inadvertently or intentionally contaminating the confession by having the interrogators leak information about the crime scene or about the crime itself to the suspect. And this does happen inadvertently because of all sorts of reasons, but it can also happen intentionally. And here, it's very dangerous when you have a contaminated confession because it makes it seem believable to a jury and to the cops, right? So if you're inadvertently leaking crime scene information, you don't know that you did it, and then the suspect picks it up and they confess to something that matches the crime, you think, oh, we got our guy. If you're intentionally doing it, you're able to feed the suspect information that a jury says, oh, well, they must have done it. How would they know that if they weren't there, if they didn't do it? And here, the contamination produced this wackadoo confession that had enough sort of weird detail in it that kind of matched the crime scene for a jury to believe it, instead of questioning, first of all, the fact that this was in the news every single day. So it wouldn't have had to be contaminated just by the interrogators. But then the really special things that could only have been known by the perpetrator, the airplane, etc., was clearly contaminated through questioning. And it's interesting because, you know, you can see in other interviews with other people, the same deputy sheriffs that were interrogating Chester contaminating other witnesses, you know, when they're asking them about injuries to Chester's face 8 months after the fact.
Yeah.
And they're saying, so are you sure you didn't see a bruise on his cheek? Are you sure you didn't see any scratches on his face? Like, oh, so if you had seen scratches on his face, would you have noticed? And you didn't notice it. So, you know, they're really leading their witnesses. And when you see them asking Chester, you know, did you kick her in the crotch? Did you defecate on her? Did you urinate on her? Those are facts that they're leaking from the crime scene to Chester to try to get him to pick up. He denies those. But I don't know at the time how much they knew about contamination and how detrimental that is to the truth-seeking process. But nowadays, because of inadvertent contamination, there are specific facts that are called holdbacks. And Dr. Cutler talks about this in his report. Holdbacks are facts. They can be mundane, you know, like the color of the carpet in the room or something that only somebody that was there would know. And they are intentionally held back so that you have it in your mind, you're not going to say them, so you don't inadvertently contaminate the confession. And that's because law enforcement, the whole criminal justice world is aware of this stuff happening and how insidious it is. So to me, you've got a hallmark false confession in both ways here. You've got a totally clearly contaminated confession, and you've got a totally coerced one. So it's just bogus all around. And the state really should have been able to tell that.
And what Chester testified to was that Dummett was basically telling him the general story, and really when you think about Dummett and Hess, all they really had to go on was when they find the women, they find the broken camera and the broken binoculars. Okay, there are blood on those items, and there's some hair on those items, so they appeared to have been used in the attack. And then there's the log that's got some blood on it. Okay, Dummett and Hess just ignore the crime lab notes that say blood on the log did not result from hitting. It was huge. That was huge, right? So that means the log has no damage to it. We're going to talk more about Dr. Fowler in another podcast. The log was not the murder weapon, but that's all they could go with. They had to construct this story that those were the murder weapons because that's what they had. And then there was twine around, some of the women's wrists that they had been tied together at some point. So there had to have an element of that. So they had this ridiculous story that, Chester had to tie them up so he could get back to the lodge before them, right? Which makes no sense. Right. And so they had to use those facts. And we talked about this in the evidentiary hearing. There were so many things in the confession that were wrong that didn't match the physical evidence. The log was not the murder weapon. The camera, the binoculars could not have fractured somebody's skull. The twine was not broken. It was cut. There was two different types of twine, 20-ply and 10-ply. 10-ply wasn't even used by the lodge. 20-ply was common twine. I mean, all these things, but Dummett and Hess just had to build a story around these few little details that they had, and that's how it went down, other than the airplane. So should we talk about the airplane now?
Well, I just wanted to take, before we get there, one opportunity to just rail again. I know I'm beating a dead horse, but
rail away.
As you just said, the evidence did not match the confession. The evidence was sort of known at the time, but we had a lot more analysis of the crime scene evidence in 2022 than we did then. The fact that the judge credited the confession without any additional analysis because the jury accepted it and said, we accept the jury's view that the confession was true, is just such a dereliction of duty to study the evidence. And of course, we know Chester confessed. His confession makes no sense. It doesn't match the evidence. And the jury accepted it because they weren't instructed about false confessions, because they were misled about what the evidence showed, and because the deputies Hale crafted the confession to match what they thought the evidence showed. But it's clearly all just a whole bunch of nothing there. And the fact that our judge at the third stage hearing just right out the gate said, it's not my role to question what the jury found, and they found that his confession was true, is just really pulling the wool over your eyes in a way.
That is your role. That is your role. That's your one role. My God.
Yeah. And I mean, when it's staring you in the face, I just can't, it's hard for me to conceive of a person who's looking at this report, which the judge had. Wasn't supposed to rely on it because he excluded it himself, but you got this report, you've got the confession itself, you've got Hess and Dummett sort of admitting to what they were doing there, trying to coerce it, and then you've got the obvious contamination, and you're just going to say, well, the jury bought it. Anyway, that's my.
Yeah, well, if that's the case, then you could never undo that. You could never successfully get your conviction vacated, because at the end of the day, if the judge says, well, the jury's believed the confession, then it's checkmate. You can't overcome it. I mean, the whole point is to do an assessment now, an independent assessment by the court of the new evidence in conjunction with the old evidence together, like taking them together, not taking it as a checkmate, just assessing the strength and weaknesses of it, because it was a weak case. It was a weak case. My attitude was, you have to basically say, okay, if we had a retrial and we had our new evidence and we had the old evidence, would there be reasonable doubt? And it was a resounding yes. my response is, if we just had a retrial today, based on the trial evidence, we would get an acquittal. I mean, if you and I represented Chester Weger and we just had a retrial and we just put on the exact same evidence, we would get an acquittal because it's so ridiculous, right? And we can cross and bring out points that weren't done as effectively. And the judge, again, on that was like, well, you know, he made a comment like, well, that could have been done, or, you know, those points were no. Oh, when I brought up the fact that the timeline in the record, Dr. Maloney saying the women would have gotten blood in their lungs between 30 minutes and an hour of eating food. And I reconstructed, they checked in at 12:28. They came back 10, 15 minutes later, went into the dining room to have lunch. Give them 45 minutes, it's 1:30. There's blood in the lungs by 2 o'clock or 2:30, according to Dr. Maloney. And at 2:40, Emil Bohm testifies at Chester's trial. He sees Chester in the men's bathroom. Okay, that right there, the state's own evidence is reasonable doubt, you know? So Chester testified that Dummett was basically telling him what to say, filling in the story, because there is no story, right? And that's why the story makes no sense, because they had to make it up. And so Chester testifies, Dummett's telling him the story. Well, one of the things in the confession, and I remember when I read this, it was another one of the numerous things in the confession, like, well, that makes no sense. Where we know when the women are found, there's twine around there's cord, like, you know, around their wrists. So that has to be part of the story, right? So Dummett comes up with this theory that, okay, he has Chester say, so the confession, Chester says, I had to tie them up so I could get back to the lodge before they did. Okay, let's pause there. First of all, Chester's 21 years old. He knows that wooded area very well. He knows where the trails are. He's going to get back to the lodge based on his age and you know, fitness before the 3 50-year-old women, okay? So he didn't need to tie them up in order to do that. But second of all, who cares who gets there first? Because let's say you got there, you know, a half hour before they did, okay? And you're now working in the lodge. If they see you, they're going to say, hey, that's the guy that tried to rob us in the park. So getting there first doesn't keep the ladies' mouths shut. It's a stupid explanation for why they got tied up that makes no sense. But I had one of our court supporters, you know who you are. This was amazing detective work. This actually is going to blow everybody's mind. I still can't believe this. I'm showing you, and watch this on YouTube because you can see what this looks like. Startling Detective Magazine. I didn't even know this existed. September 1960 issue. Look at that amazing cover, okay? And there's a big article in here about the Starved Rock murders. September, that's when all the shit starts to go down with Chester Weger. September, okay? And so what's interesting, and I'm going to turn to page 94 of the magazine. The author of the article talks about, he kind of gives his version of like, hey, maybe it went down like this. And I'm going to read you a part that I'm pointing to right here on page 94. And so this is what the author says. And the main part's going to be the second paragraph I read. I believe that the women then capitulated to robbery, but not rape, certainly, and the homicidal sex maniac herded them back into the canyon. He then probably told the women something like this, and he's got in quotes, I won't hurt you, but I must tie you up so you won't be able to follow me immediately. I must have time to get away. After I'm gone, you'll be able to free yourselves. Doesn't that sound awfully similar to what is in the confession? And what the person who found this said to me is, could it be that Deputy Dummett read this article and being such a dope, decided to incorporate that part into the confession? I think there's a very good chance of that, because that makes no sense. I actually had somebody reach out to me who was a paramedic and reach out to me because here, what the autopsy said and what the crime lab notes said was that there was no tension on the women's wrists. So there were no cord impressions on the wrist. So under Chester's confession, he tied them up so he could beat them back to the lodge, which is a bogus BS story. Okay. And that they broke free. Okay. First of all, the women are not going to be able to break free. They're not going to be able to break the twine. And what the crime lab notes noted was the twine was cut, and newspaper articles said it was cut by two different types of instruments, one sharp and one serrated. But here's where I'm going with all this. And I was like, well, that's so weird. Why is there no tension on the twine around their wrists? What this EMT reached out to me and said was, we oftentimes would tie people's hands together when we were moving those bodies. We didn't want the hands just dragging on the ground, catching on things. You tie those hands together to transport them. So it very well could be that the women were tied to basically drag their bodies into the cave, where they were then cut apart and then displayed. That's what makes a lot of sense. Not that Chester Weger tied them up to beat them back to the lodge and that they broke free, and the evidence doesn't submit that. So I thought that was really interesting. Absolutely.
And, if there's multiple offenders with tire irons, you wouldn't need to tie them up to subdue them, right? So
No, exactly.
That's an alternate theory too.
Exactly. And let me, since we're on this, talking about what's in the confession, let's just get into the airplane, because the story, and again here, this is what's used. This is what comes up over and over. Like, what about the airplane? What about the airplane? What about the airplane? So the theory was, Chester sees an airplane overhead and thinks now he might be spotted, so he's got to put the bodies in the cave. Okay. First of all, let's pause there. If the airplane saw you, they saw you. So taking the time to move the bodies one by one into that cave, which is hard, sure seems like a waste of time when somebody could walk into that canyon at any moment and you're going to get discovered. So I think the fact a plane flew overhead, who cares, right? And what could you even see from up there? The second thing is, it's not like Chester just took the bodies and threw them into the shallow little cave, right? Like, I'm just going to throw the bodies up here. No, the cave is this kind of elaborate, thoughtful, grotesque, sexual Halloween display where the bodies are spread apart. Their legs are like spread eagle. The skirts are pulled up. The underwear is pulled down. This took time. This took kind of devious thought. It's not like, there's a plane flying overhead. No, that's not what's happening here. There's a much, there's nothing in the confession about like, why did you spread the bodies about that? Or did you rape them? Or why did you pull their pants down? Why did you do them spread eagle? Like, there's nothing in the confession about that. There's nothing about, why did you cut off Miss Murphy's fingertip? So the airplane part, I believe, and Donna Kelly, Chester's former attorney, did some amazing work on this. She determined that Dummett was a member of the Ottawa Airmen's Club, flew planes, knew the people out at the airport, would have had access to all those flight logs. And there very well may have been a plane flying that day. I'm not saying there wasn't, but created this whole BS ruse, put it in the confession for this very moment, because everything else was bogus and he needed the plane part to give it some credibility.
Right, absolutely. And I wanted to point out too, this is a piece of new evidence that you all found back before I was on the case, but these are Harlan Warren's notes. And we can put this on the website, I guess, because it's a little bit hard to describe what it says. But it's sort of point counterpoint. So this sentence here says, these are Harlan Warren's notes. It says, how would Deputy Sheriff know they flew? Wayne said deputy made this up.
So interesting.
We don't have the context for that, but it's a little fishy. Wayne said deputy made this up. Just that. Checked, was plane flying around, checked Ottawa Airport.
That sounds like Wayne Hess is saying to Warren, well, Dummett made that part up.
It sure does.
Yeah, that's amazing. That's amazing. Those notes are the confession of what these three evil men did to Chester Weger. The notes are the real confession right there, That just haunts me. What you just read there just haunts me. My goodness. So this whole part about Dummett kind of telling Chester what to say in the confession. And the other thing is, like I said, they had to go with the limited facts that they had, the bogus story that they had. Let's transition to the part where let's first talk about, before we get to the part like the factors in this case, tell me about what Dr. Cutler said about the Reed technique, what the Reed technique is, and commentary about the Reed technique in just a few years later in some very powerful Supreme Court precedent.
I believe it was last week when we were talking about the Miranda opinion that I sort of out of hand said, they didn't just take Chester to any old interrogator and polygrapher. They took him to the person who wrote the book on interrogations. And I meant that literally because John Reed and his partner Imbaugh, they wrote one of the most popular and most used manuals on how to interrogate and extract confession. And it's been published 4 different editions and widely used because it's effective at extracting confessions.
And hold on, I think I might have that book. Let me go check. Hold on. Aha! I do. So people go to the YouTube version. You can see what I'm holding up. It's an old book. It's called Truth and Deception: The Polygraph Lie Detector Technique, 2nd edition. John Reed and Fred. How do you pronounce his last name?
I've been saying Imbaugh, but Imbaugh.
Yeah, and this book. Yeah, I got it for this very reason. So go ahead, keep telling us about Dr. Cutler said about the Reed, who John Reed is, and this technique.
Yeah, so those two, they're very prolific because they also wrote Criminal Interrogation and Confessions, and the first edition of that book was published in 1962. So I wonder if there's any little anecdotes in there that relate exactly to what he did to Chester, but I can only guess that he was building material for his book at around this time. So the most recent edition of this book basically sets out a process to extract a confession that consists of 9 steps. So step 1 is you have to positively present and confront a suspect with a statement that proves he's the person that committed the offense. So you basically, it's an accusatory technique that you start, like I said, from the premise where you did this and we're going to get you to confess to it. One of the ways to do that is by preempting denials, because psychological research shows that people dig into what they've already said. So if a person denies wrongdoing, then they attach to that and they're less likely to confess. So you try to prevent them from being able to actually deny what they did. So you start with stuff that they did do, you move to stuff that they didn't do. It's a cat and mouse game here that is actually pretty smart. So like I said, there's 9 steps, and it's a little bit too much to get into step by step what you do, but a lot of it is telling the interrogator how to assess and analyze the suspect and how to recognize when you're edging them closer and closer to a confession that you want them to say, and how to get there, and how to avoid them invoking their rights, how to avoid them losing patience, especially if they're cooperating. And so these techniques were considered an improvement upon techniques that were used before, which was physical violence and threats and coercion and torture. So certainly they are an improvement from that, but when leveraged in a way that is intentional or improper, they can certainly override the rights that are constitutionally guaranteed to citizens. So somebody who's using the Reed technique responsibly has to be very careful not to wade into unconstitutional territory. And that's the most recent edition of the Reed technique. Certainly that's been adapted for advances in.
And so really what you're saying, it's not so much like we're going to hook you up to a machine and ask you questions. Did you kill these ladies? It's no different than a police officer just sitting in a room and browbeating the suspect and trying to get them to confess. I mean, it's just a technique to try to get somebody to confess. It's not the science of, we're going to hook you up to this scientific machine and check the responses to your breathing and, your blood pressure and stuff. It's more like, hey, what kind of technique can I use to get this person? How can I break them down?
Right. Well, and it's interesting, like, why is it so important to extract confession from a suspect even when they're guilty, right? because confessions are so powerful with jurors.
Right.
Juries love confessions. They need confessions. You know, there's a lot of confession-only cases. And assuming that those cases have a guilty person that they got to confess, and that's their only evidence, well, great, you solve the crime. But if they weren't such a powerful tool in the prosecutor's arsenal, then they wouldn't need them, and they wouldn't go about trying to get them, because they can be really dangerous if they're not supported by corroborating evidence, as here.
Yeah, and I think, you know, today, I don't even think a state's attorney's office would bring a confession-only case. I don't think, in these same facts, I don't think Chester Weger get charged if all they had was a confession. And the reason I think they went so hard back in 1960 was because they didn't have anything else. They
Right.
had to get a confession to have something. Remember, we got to keep this all we got to remind everybody over and over again. Women are murdered in mid-March. Confessions mid-November, 8 months later. The Palmatier brothers have evaporated, okay? The real perpetrators have been kind of discovered. Like these guys on the phone know who's the guy with the bloody overalls in the trunk of the car. Okay, he's in on it. All that, the cover-up, whoever's in on that, some very powerful people, but clearly the state's attorney's office is in on it. The LaSalle County Sheriff's Office is in on it. I think the Chicago Mafia is in on it. They make that go away. And now we're in the context of we got to find somebody else to pin this on. That's why you get the Reed technique, and that's why it wasn't like Harlan Warren's calling in the Illinois State Police for polygraph number 7. All right, Chester passed 6. He's calling in his special ops unit to try to extract a confession. They needed to get a confession.
And, you know, that's one question that's come up when I've been talking about this case to friends and family is, you know, what was their obsession with Chester? Why did they, because a lot of people don't believe that the state, that, you know, our government, the police, the powers that be, would ever just want to railroad somebody for no reason, right? There's no motive for them to do this to Chester. So Chester probably did it because he confessed. Like, why would they force him to confess? Why would they try to get a confession out of him? And when you peel back the layer and think they don't need Chester to confess, they decided Chester was going to be the one because whatever reason, what they needed was for the real perpetrators not to be found.
Correct.
Right? So the motive
Correct.
is not to get Chester. They just, Chester,
Yes.
you could say collateral damage.
Yes.
And
Exactly.
what they're doing is protecting somebody else. And I think that's important
Yes.
to note. And when you put it all together,
Yeah.
it's very obvious. And you know who's doing it? Harlan Warren. You know, the Illinois State Police did follow through with the Palmatier brothers. They had surveillance on the bar. They traced the calls. They found Los
Yeah.
the most
Yeah.
reliable witness.
Yeah.
They did the polygraphs where Chester's passing. And then every step of the way, when things take a left turn against the truth.
And they even go one step farther. So they did, by the time they interviewed Glenn Palmatier on August 30th, they've been in the bar, drinking, hanging out, doing surveillance. They already know this Lupe Cardenas guy. They know his name. They know he's got a criminal record. Why are they bringing up Lupe Cardenas? So to Glenn Palmatier, it's not like Andy Hale, injected Lupe Cardenas into the case. No, the Illinois State Police thought it was significant enough to say, hey, why are you talking to this Lupe Cardenas guy all the time, right? What's going on here? I'd love to know what else the Illinois State Police did. We don't have the William Palmatier interview, okay? Glenn Palmatier, I think, may have been telling the truth when he said he wasn't the one on the phone. I think it was Lupe Cardenas because the way Lois Selensik describes, she actually says, big burly man, limited vocabulary, sounds like he's talking to the boss. We know that Lupe's with Glenn every day. It sounds like it's Lupe, but what is William Palmatier going to say? The call is traced to his house. What is he going to say? In newspaper articles, he denies the call. Well, that's just bullshit. I mean,
and of course, his brother says,
Yeah.
"Oh yeah, we talk all the time." I probably called him 5 times that week.
and he thinks they talked that day. I mean, so that denial. Why isn't William Palmatier being brought to Chicago for a 12-hour grilling and then back to the state's attorney's office and all that? You know why? Even if they tried to, he'd have said, "No, I'm not going." He'd have said, "Oh, I'm not doing any of that stuff." Chester didn't have to, but the powerful people made this go away. I mean, think about this, Sally. I mean, this is what we got to pause. Let's pause here a minute. Let's just take 2 seconds to let it breathe. Think of how powerful the people had to be to make all that go away. because you got the Illinois State Police saying, hey, we traced the call to these brothers. We've got a guy with bloody overalls in the trunk of a car. We've now cracked. This is such a huge lead. This is the case right here. And to think that literally a day later, there are those profuse apology letters written. Think of the power of how that happened. How does that happen? And if it's not, I believe that the Chicago Mafia is involved. And even if it's not, it's very, very powerful people. I think, my personal opinion, Robert Murphy and the people he knows and his connections and cronies to make this go away. Here's the other interesting thing. In that Glenn Palmatier interview, well, there's a part where I think all the police are kind of like debriefing afterwards. At some point in the transcript, it says, Harlan Warren stepped out to take a call from Mr. Murphy. It's like, really? Robert Murphy's calling him during this? Huh. Yep. What's going on here? And then Glenn Palmatier knows Robert Murphy, and he brings that up. So you're right. It's not so much we're focusing on Chester. We've got to make sure these other guys don't get charged with it. Okay, so we've got to go down another road. My gosh, let's pivot to... So basically the way Dr. Cutler does his report, he goes through all and I really urge people to read it. He goes through all the history and the research of false confessions, the factors, the types. And then he talks about the Reed technique. Is there anything else you want to talk about the Reed technique? Which is fine.
No, just to mention, we mentioned this last time I was on, but that the Reed technique was basically the precursor. The use of the Reed technique was a trigger for the Miranda decision itself. So it's cited a bunch in the opinion. Reed and Imbaugh's interrogations manual was cited with disapproval by the court when they were deciding that have to be advised of your rights before you're put in a room like this. So I think it's just the history here of this case that this case represents it's kind of tragic. The exact techniques that were used against Chester, by the guy who wrote the book, would not be allowed. Just
again, we could not. You and I. Let's just picture this right now. We're doing a Zoom call, and you and I are both aspiring screenwriters, and we're like, okay, well, let's have the former Chicago police officer be the polygraph examiner. We'll have him write a book about it. Then we'll have the Supreme Court mention him in some of their opinions. Like all this stuff we're talking about. Let's have a big burly chief come in the bar and hang out with Glenn Palmatier. I mean, it's you couldn't make this up. But let's get to on page 27 of his opinion. Then he starts a section. Dr. Cutler says review of Mr. Weger's interrogation and confession, and then he walks through some of the factors. He kind of walks through the facts and the factors. You want to kind of summarize what he said here in those? It looks like there's about 6 or 7 pages. There are pretty detailed findings.
Dr. Cutler is only basing his opinion on the facts known and accepted by the jury. So when there's a disputed fact, he doesn't credit us. He doesn't say, oh, well, because he said Little Green Room, that means that it actually happened. So these are the factors that he's finding, even accepting the state's version of events as well. Okay, so it's a conservative depiction. So the risk factors that he identified would be the length of the interrogation, those 30 hours, isolation. Chester was not just isolated in a room, he was dragged up to Chicago. That's highly isolating. Sleep deprivation and fatigue. Of course, we know that he was helped overnight. He was brought right back to the state's attorney's office when he's been on this arduous, crazy journey. False evidence ploys. So it's not known whether they actually used false evidence ploys, but it seemed as though they likely did in terms of suggesting that they had all this evidence against Chester to him. And Chester says that they used false evidence ploys, not in those words, but the state denies that. So I think we can assume that they used the Reed technique, so they used false evidence ploys. Explicit threats, those were present here, obviously with the Thunderbolts. That's one example, but Chester accuses them of additional ones. But even if those weren't true, the Thunderbolt is enough. That's a very explicit threat of extreme violence, right?
Yes.
And then They also used other tactics, including making disparaging comments about Chester's wife and family, appealing to leniency, and just insulting him, kind of raising the temperature in the room and adding stress to the situation. And, why do people falsely confess? Because they want to get out of a really stressful situation that is intolerable. And so how do you make it intolerable? Just heaping whatever you can onto the flames. Dr. Cutler was not there to say whether or not Chester's confession was false. He was there to identify the risk factors that would make it more or less likely to return a false confession. And there were a lot of them present here. And to ask that a fact finder not consider that and rely on their lay knowledge of what a false confession is and what it results from is really removing a really exculpatory piece of expert testimony from the case. So the jury certainly should have been able to consider this if we got a retrial.
Yeah. And the other thing is, so people know, so Chester, they extract this confession from him November 16th. I think it's late at night. The very next morning, 7 a.m. or so, he's out at the canyon. They want him to reenact the crime. That's when we do have a transcript. They got a court reporter kind of following them around. And that's when Wayne Hess asked him if he defecated or urinated on any of the women or kicked any of them in the crotch. Okay? That's not in the confession. I mean, clearly they know, we haven't addressed why there's somebody defecated or urinated on Miss Murphy, And so they're asking him that, okay? He doesn't know. And it's so telling that they're doing that the very next morning. Let me read the summary of Dr. Cutler. This is on page 33 and 34 of his opinion. I'm just going to read you the summary after all the things he went through of what he said. Okay. Mr. Weger, a young adult at the time of the investigation, and therefore vulnerable, became the sole suspect in the investigation about 6 months after the crime. Mr. Weger was subjected to extraordinary pressure during the murder investigation in September through November of 1960. He was subjected to questioning, a polygraph exam, surveillance, and 2 lengthy interrogations. Evidence baiting and bluffs were used during the interrogations and investigation, though they were not labeled as such by the authorities. Those facts are agreed upon by the parties. Mr. Weger claims to have been threatened with the death penalty if he did not confess, and offered a life sentence if he did confess on numerous occasions during the questioning periods and interrogations, and by numerous authorities, a fact disputed in the testimony of the authorities. The sheer pressure of the weight of suspicion, the multiple questionings and lengthy interrogations, the likely tactics used during the interrogations alone create a grave risk for false confession. If the false evidence ploys were used, the risk of false confession would be magnified. The use of explicit threats and incentives, historically and contemporarily by trainers of interrogation in courts, alone greatly increases the risk of false confession. If used against Mr. Weger, they were in combination with other oppressive tactics. If innocent, Mr. Weger was in grave risk of being coerced into a false confession. Mr. Weger's detailed confession statement might be the product of contamination from multiple sources, including the deputy sheriffs, the newspapers, and talk around the lodge. The disputed facts, the source of the details in Mr. Weger's confession, and the context to which those details are corroborated by the evidence in the case are matters for the fact finder to determine. So that's what he says there. And his report is dated January 15th, 2023. So I just think I go back to this would have been such powerful evidence if it would have been heard in a third stage hearing or at a retrial. And I think it was egregious legal error for the court to keep it out. And I think that's kind of when the court started laying the foundation for what it ultimately did, right? The judge first laid the foundation for the denial by barring some of our key evidence, including Dr. Cutler's report.
Yeah, I mean, it is a shame that we weren't able to, have a crystal ball and foresee that this stuff was coming together. We thought we had every single piece of our evidence we thought would win the day. So when he excluded this or that, we thought, well, that's not going to be the key piece. But actually, every single piece was a key piece.
Yeah. Yeah. Oh, deep sigh. Deep sigh. Well, Is there anything else you want to say about Dr. Cutler and false confessions before we wrap things up? I really appreciate all your insight today.
No, the only thing that I have to say that I think bears repeating is that jurors today still don't believe false confessions are likely because we, as people, lay people, we think that the only thing that could get us to falsely confess to something we didn't do is, a threat of violence against ourselves or our family. Here we do have threats of violence, but people, I think that's what gives an innocent person this confidence to just go in and talk to an investigator, to do, to cooperate with authorities, and you wind up in a position where you're vulnerable to a false confession just because you have such faith in your innocence. So people out there, ask for a lawyer.
Yeah, absolutely. I mean, and I want to mention to people, the way I got into the whole post-conviction process and where I'm at now is I first made a documentary movie about a false confession in Chicago with a guy named Hale Simon. The movie was called A Murder in the Park. That documentary basically caused the state's attorney's office to roll up the sleeves, investigate the case harder. The case had been pending, the post-conviction, for 10 years. But the documentary is what finally, I think, got Hale Simon exonerated. And it was on Netflix. It was on Showtime. I think it's actually back on cable now. Check it out, A Murder in the Park. You can also rent it on Amazon. And there's a scene in there where Hale Simon has got a tear coming down his cheek. And, he's the one who falsely confessed. And he says, you could be put in a situation where you do something you don't want to do. And so I realize now, after seeing Hale Simon, Kevin Fox, and other cases, here's another one. I met this guy named Jeff Deskovic in New York. Okay. 16-year-old kid. They get him to confess to the murder of his classmate. Okay, look up Jeff Deskovic. This is an incredible story. And he confesses, he gets convicted of the murder. He spends 16 years in prison. And then, I've got goosebumps again. Through DNA testing, they find the real killer. Jeff Deskovic falsely confessed 100%. Same with Kevin Fox, 100%. There's no doubt. And you would say, well, who would do that? Well, you know what? Until you're in that situation, you don't know, you can't say. And maybe certain people are more vulnerable to those techniques. Maybe not everybody is, but some people certainly are. And so Jeff Deskovic, Hale Simon, Kevin Fox, Chester Weger, those cases are out there. And this evidence of a false confession is so powerful that we backed it up. And I come back at this, and this is where I go back again with Will County, with the way the tone they used to kind of mock our advocacy for Chester Weger, the way they mocked our whole case. I mean, Will County knows about Brian Cutler. They had his report. They read it. They were aware of it. Whether the judge allowed it or not, that's something that they should have considered in their analysis of the case. So in light of all the things we talked about, for Will County to basically mock our case and have disdain for our case and just have the kind of tone they had for our case is really stunning. And in my opinion, not consistent with their duties, which were to seek justice. But the last chapter has not been written. We still have a lot more to do and say. You and I are working behind the scenes. We'll have more to talk about on that in a podcast hopefully soon. Sally Cohen, always a pleasure. It's been great to have these podcasts with you, breaking down the law and the facts. To be continued, everybody. Thank you for the love and support. Stay tuned. More to come.